believe the designation has been changed to a Seattle designation, although this case originated in Kent. Let's begin. We're here for a review hearing, and let's begin with the parties present identifying yourselves on the record. And let's begin with the petitioner, the state of Washington.
Good afternoon, Your Honor. David Ross.
It's not afternoon, Mr. LaRosse. It's still morning. It's been a long day for you, but. Good morning. All right, David LaRosse on behalf of the Attorney General's Office, the state of Washington. And the social workers. We have, you're muted.
Here, try talking now, Emily.
Okay. Is it working now? Is it working now?
Yes, it is.
Okay. This is Emily Plager, social worker.
Thank you. And it's pronounced Flager?
Yes, that's correct.
All right, thank you. And do we have...
Hi, this is Julie DeCamp. I'm the supervisor assigned to the case, and I am just observing today.
All right, thank you, Ms. DeCamp. I just wanted to have attendance of those who are present. I will note that Ms. Smith, my bailiff, has gotten many email correspondences from Ms. Zayas, who was notified of this hearing. At one point she had accepted, the invitation for the Zoom link, but as of today has sent notice that she has no intention of participating. She says I'm being sued, but I haven't been served. I don't have any formal notice of that. And so I'm not certain of the circumstances. I am certain that she has had notice and opportunity to participate, and I do have several written responses that she submitted in anticipation of this hearing. And I guess I would ask Mr. LaRosse whether you received that correspondence from Ms. Zayas as well. I have something called just a memorandum, which is essentially a compilation of quotes about referring to the fact that drug use in and of itself is not reason for dependency action, and then also a motion in order to strike unsigned orders. This was filed with the court. It's not noted in some way. It's based on, she purports to base it on Rule 11, and then I also have a statement that refers to why there was not a change of judge granted in her case. That's sort of the gist of it. Have you received that documentation, Mr. LaRosse?
Yes, Your Honor. I haven't responded because there's no, despite the clerk's reminder to Ms. Zayas, she hasn't included any notes for motions. She hasn't actually noted any of the motions up. So I would indicate in the proposed review order that she has filed reports to the court, but none of them have been noted, so I have not responded to them. They're properly noted motions.
All right, thank you. And I agree with that. The only of these submissions, the only one that requests relief is the motion to strike unsigned orders. The others are really just sharing information and statements. And I have reviewed her submissions as well as the department's submission and the report from the department for review of this matter at this time. So I am familiar with the submissions that have come before the court. With that, Mr. LaRosse, I'm going to turn it over to you to walk us through the proceeding.
Yes, thank you, Your Honor. So this is an initial progress review hearing. It is the first review hearing to take place following entry of an order of dependency. And as such, the department is not requesting for it in the permanent plan that was ordered in the dependency proceedings because it's early to do so despite concerns about the mother's engagement. The primary plan, therefore, is set in 2.4 as return home to the mother. There is no alternate plan, and the department is not requesting for a change of plan at this time, again, because it is so early. The department is not aware of any new information to indicate that the child is native as defined in ICWA or WICWA. And the April 21st is indicated as the projected date for return home of the child. That is an aspirational date. The department has made reasonable efforts to implement and finalize the permanent plan for the child. The court has been privy to a number of filings and a number of emails with the mother in which she has been urged to participate in the ordered services. The department's court report was timely submitted. There was not a CASA report because the CASA has returned to pending status. Pardon me. Ms. Duke came onto the case for the purposes of the trial, but she's a rotating AGAL who is primarily used for that purpose to deal with cases where a CASA is needed for trial. And so once the trial concluded in this matter, she withdrew from this case so that she could move on to appearing in other cases as needed, where a CASA was needed. I have indicated that the mother has filed a number of pleadings, which are sort of reports to the court. They're more complaints rather than reports about her progress. The placement of the child remains with the department in foster care. There isn't a suitable person or relative who has been identified and is appropriate to care for the child. The child is doing well in relative care. She's having visits with her mother. It is an appropriate placement that adequately meets all of her physical, emotional, cultural, and educational needs. There are no known appropriate out-of-state placements for the child. The department has made reasonable efforts to provide services to the family to eliminate the need for out-of-home placement and is in compliance with court order. The mother is not in compliance. She has explicitly and repeatedly declined to engage in any services, and I would characterize it as perseverating on the idea that the 72-hour order was forged, even though she was present for the proceeding and represented by counsel. She continues to maintain that it didn't happen, and she's really not focused on doing any services, and therefore the department is requesting a finding of no progress in correcting the problems that necessitated the child's placement in out-of-home care. The father is unknown and has not come forward. Therefore, the department is requesting findings of no compliance and no progress as to him. The mother has visited the child on a regular basis, The unknown father has not. And that is heartening. But again, there's no real progress towards correcting the deficiencies just by participating in visitation, and she absolutely refuses to cooperate in participating in any services. The child does not have siblings, so that there's not court-ordered sibling visitation. And so we are requesting basically a status quo order with no changes to ordered services or visitation or placement or change in permanent plan. Thank you.
Thank you, Mr. LaRosse. Just a couple of clarifying questions. One is, I wanted to confirm that the child is still in the second foster home placement that she was placed in. There was one placement, and then because of some kind of privacy confidentiality issues, she was moved to another home. She's continues in that second home, is that right? There haven't been moves since then, as I understand it.
I believe so. I'll defer to Ms. Flavor on that issue.
That is correct. Amaya is still in the second placement.
All right. And in reviewing the report, it sounds like she's doing well in school, that they're actually having some, or were at some point, I mean, it's kind of hard to keep track of, some in-person schooling in a very small setting, that she was doing well both in coursework and in her social contacts, making some friends, feeling positive about the school environment. Is that your understanding, Ms. Flagler?
Yes, that is correct. She's still in person at school to date.
And one other thing as far as the child is concerned, only because it's part of Ms. Amaya's ongoing complaint, references to the child doesn't get proper grooming, or her hair isn't taken care of, or, you know, that's really, this more succinctly, what she says is that her hair isn't combed. How do you respond to that, Ms. Flagler?
Yes, there's been a lot of concern brought up by Ms. Zayas about Amaya's hair care. An intake was actually called in, and there's an investigation. They went out and interviewed the foster parents and Amaya. That investigator noted being introduced to all of the hair products that the foster mother was using, and she approved of all of them, having personal experience using those different hair products. It was also brought up that Ms. Zayas, during a visit, had put in a certain hair product that actually damaged the hair and therefore caused breakage when Amaya's hair is brushed, and therefore they have to be more careful and not brush it as much. And that's something that will just have to be healed with time as her hair grows out and continues to get trimmed. That was explained to Ms. Zayas, but she continues to make complaints that her hair is not being cared for by the foster parents. The intake was closed as unfounded.
All right. Well, I appreciate that. That's good to know. It's good to know, even though I know that Ms. Zayas's complaints are sometimes really far-fetched and without any credibility. As the trial demonstrated, she loves her daughter. I think she's hurting around all of these events, and it is our responsibility to make sure that the child is well cared for and feels good about the circumstances, although I understand from the report that that it's emotionally challenging for Amaya after visitation. And that's understandable. That certainly is a logical for a child. But if you would speak to how the foster mother or parents respond to that, and how Amaya is weathering that sort of emotional roller coaster that is created by being in foster care and having then regular visitation with her mother. How is that being addressed by the department?
The foster family, especially the mother who's present when Amaya is dropped off after visits, does a really good job of checking in with Amaya after each visit. I think it should be noted that yesterday was a somewhat traumatic visit for Amaya. Ms. Bias had to be escorted out of the building by security. As reported to me by the foster mother last night and this morning, that Amaya was pretty sad upon getting dropped off. She tries to speak with Amaya about her feelings regarding visits and how she feels seeing her mother. Amaya is usually pretty quiet about sharing. This morning and last night, it was reported that Amaya just mentioned that she was sad and that the visit was hard. And when asked why she was sad and the visit was hard, Amaya said that her mother got in trouble for arguing, and then that ended the conversation. That's typical of the conversations between the foster mother and Amaya. She's pretty limited in wanting to talk about it, and that's true during her counseling sessions as well. She doesn't really like talking about it. It's just noted that there are a lot of behavioral shifts following visits. It's getting better as she's gotten more assimilated in the foster family, but she still does have some outbursts of anger and frustration, and it's kind of hard for her to return to baseline during the evenings following the visit. I think this is attributed to not only how the visits go with Ms. Bias, but also the length of the day for Amaya having to go to school and then travel up to an hour to the office for the visit. It's just a lot for her. And but was noted in my court report that her counselor has reported that Amaya has mentioned she feels crazy after visits and when she's with her mother. The foster parents are doing a really good job of just trying to check in with Amaya after each visit, as I mentioned before, and giving her space to share her feelings around that. They do mention that Amaya never brings up her mother and only rarely talks about her following the visit. But they do a really good job of making themselves available if she does want to speak about it.
All right, thank you. I appreciate that. I think a status quo continuance is entirely appropriate under these circumstances, and as Mr. LaRosse says, this is an initial review. I do want to just put an issue out there, and I don't necessarily know that today we have a solution, but I want to raise it, and that is, Messias has a point that there is a lot of authority for the fact that illegal activity or substance abuse alone is not grounds for dependency. It's the risk to the child and harm to the child that is the focus of our attention. Here, it's not only Messias's history of drug use, which is extensive, but subsequent mental health issues for which at this point it's probably impossible, and I'm not sure it's even relevant to sort out chicken and egg. you know, whether the drug has exacerbated mental health issues or mental health issues pre-existed and, you know, are just continuing. You know, the finding after trial was, and I think it was justified by evidence, that that Ms. Zayas's erratic and unpredictable behavior, her obsessions with a variety of things, including the fact that her denial of drug use and litigation and resisting, you know, the services that were being offered, all of which put Amaya at great risk, and she seems to be doing very well in this setting. But I'm not sure how we all deal with that going forward, and because obviously Ms. Zayas has just adamantly resisted any involvement in the services, and I don't know what the abilities are to engage her in some way, nor do I have any insight into how successful any engagement might ultimately be on either the mental health front or the substance abuse front. But I just wanted to throw it out there because I do think it presents kind of a conundrum for us as far as moving toward something positive, because the indications today, and that's just today, 3 months into it, are that status quo isn't going to get us anywhere. So that's my observation.
Yeah, John, I do want to clarify one point. When I said status quo, I didn't mean that status quo would be indicated on the order verbatim, simply that the findings would be. No,
I totally understand that. I just mean if every 3 months we come back and do this, then there is no, you know, and maybe that's it. Maybe, you know, maybe it all falls on the mother to at some point engage, but I understood what you meant, and that there was no change to the original order, and I absolutely agree that that's appropriate at this time.
Yes, and in regards to the court's concerns, I mean, the problem, I don't know if I should say it's a problem, but the situation is that the department does not have the ability to involuntarily commit a person, and so there's really nothing that can be done on the department's end other than making the offer of the services, and the court having ordered them so that she is required by court order to participate.
Yeah, I'm thinking more about probably, and maybe this is completely undoable, unmanageable, but I'm thinking more about the mechanisms that are used to reach out rather than putting the onus on Ms. Zayas to call this number or make an appointment or whatever. Clearly she's not doing that. So I just don't know what tools the department might have to approach things in a different way. And you are right. And I can't say that there would even be grounds for involuntary commitment, but how creative we become in trying to engage her in some kind of service, I think, is the open question. And I'm not doing it. So I just wanted to raise it as an issue.
I mean, she has to buy into the concept of participating. So, for instance, if the department, instead of saying, you've made a referral here, please go and sign up for an evaluation, say, if the department said, we've made a referral and set up an appointment for you on this date and time, I don't foresee that Ms. Zayas would be any more likely to appear for the appointment if the department made it, and then that just sort of wastes the provider's time.
Well, you may be right, and as I said, I don't purport to have an an answer to that, but maybe someone showing up at her door and saying, hi, you know, let's talk. I don't know. I don't know. Ms. Flagger, it looked like you were trying to comment, or?
Yes. Since I took on the case, I have made different efforts to engage with Ms. Zias. I've met with her in person in the lobby prior to visit, to be able to talk with her in person and present her with her service letters rather than mailing and going over them with her in person. She typically just folds them up and says they're irrelevant because she's filing an appeal. I make sure to tell her that while we're waiting for that to occur, that the court order stands and that she still does need to participate. I have called and made specific and scheduled specific dates and times for services, more specifically her psychological evaluation with parenting component. I believe she did appear for that appointment, but I've made it clear that she won't participate in any follow-up interviews or any of the recommendations. So I just wanted to make that known.